Good afternoon. Thank you so much for tuning in. It's my great pleasure to have the opportunity to again present a Supreme Court review focusing on the Supreme Court's October 2025 term, which ended 3 weeks ago on Tuesday, June 30th. Overall, again, we saw the effect of having 6 conservative justices. Most of the rulings were in a conservative direction. In cases involving President Trump, the court often sided with him, but sometimes in crucial cases ruled against him. What I'd like to do, as always, is offer a few overviews about the court, where it is and where it's going, then review the cases that I regard as most important, and then save a few minutes for questions at the end. If you have questions, please put them in the Q&A, and my terrific assistant, Whitney Mello, will read as many of them as possible. In terms of observations about the term, first, I always begin by talking about the numbers from the term. The Supreme Court decided 58 cases with signed opinions after briefing and oral argument. It's the exact same number as the year before. The court was more divided this term than the year before. 29% of the cases were 6-3 decisions, which is double the number from the year before. 23% of the cases were 6-3, where the 3 justices in dissent were the liberal justices, Sotomayor, Kagan, and Jackson. So a quarter of the cases basically on the docket were ideologically divided in that way. And I said that's double what it was just the year before. In terms of other interesting statistics, the justice most often in the majority, again, was Chief Justice John Roberts in 95% of the cases. Another statistic that I find particularly interesting is that there were only 3 cases reviewing state court decisions. The rest came from federal courts. When I speak now at Federal Judicial Conference, I say this means the chance of one of their cases getting to the Supreme Court pretty remote. Second overall observation is how much of the docket, both in emergency docket rulings and merits docket cases, involved challenges to President Trump's actions. By my count, since January 20th, 2025, there have been 31 matters resolved by the Supreme Court involving challenge to the Trump administration's actions. Most of those, of course, on the emergency docket. By my count, the Supreme Court has ruled in favor of President Trump in 26 of 31 instances, almost all of those being 6-3 decisions, but there were some notable cases this term that I'll talk about. There are tariffs and birthright citizenship, where the Supreme Court ruled against President Trump. Third and finally, I think the most important thing for the future of the Supreme Court is there were no vacancies this summer. Justice Thomas is 78, Justice Alito is 76. Each knows that if they retire now, with a Republican president, Republican Senate, someone with their values and views would take their place. There was certainly a lot of speculation about whether one or both would resign. Neither has. Quick story here. In March of 2014, I wrote an op-ed in the Los Angeles Times urging Justice Ginsburg to retire that summer. I said with a Democratic president and a Democratic Senate, virtually anyone who was nominated would be confirmed. It never occurred to me that a Supreme Court justice would pay any attention to what a law professor in Southern California was saying. But the day the op-ed came out, I got a call from a mutual friend who said, quote, "Ruth is not happy with you." She had interviews where she said, "Some, such as Erwin Chemerinsky, are urging me to retire, but no one can do the job as well as I can." Of course, she gambled. She passed away in September of 2020. President Trump quickly named Amy Coney Barrett to replace her. The Senate rapidly confirmed. Justice Thomas and Alito lived through that experience. If either would resign now, they would likely be replaced by somebody in their late 40s, early 50s, who would keep the seats in conservative hands for decades to come. There's still a chance that if the Republicans lose the Senate in November, one or both might retire and try to see if President Trump could get somebody confirmed before the Senate changes hands in January. But for now, I think the the most important development for the future of the Supreme Court is there weren't any vacancies this summer. Well, as I do each summer, I want to talk about what I regard as the most important case of the term, in terms of the law with regard to society. Obviously, I can't cover everything in the course of the hour, but let me talk about some of the areas. I've divided the cases into 5 major categories. I struggled as to how to organize it, so I decided just to go alphabetical by topic. I provided you a copy of my handout. It lists the cases in the order in which I'll be talking about them, and I'm glad in the question and answer session to talk about any of the other cases from the term. By starting alphabetically, I begin with civil rights, and this lets me start with what I regard as the most important case of the term, Louisiana versus Calais. Let me tell you the bottom line as to why I think it's so important, and then I'll explain. This decision will mean the largest loss of black representatives in Congress and state legislatures since the end of Reconstruction. It involves the Voting Rights Act of 1965. The 15th Amendment, adopted in 1870, says that the right to vote shall not be denied on account of race. But this was an unfulfilled promise. In 1964, in Mississippi, only 7.6% of eligible black individuals were registered to vote. In Alabama, it was 17%. Across the South, the states that have been the Confederacy, only 43% of eligible black individuals were registered to vote. The Voting Rights Act of 1965 was meant to and did dramatically change this. There were 2 key provisions of the Voting Rights Act. Section 5 said that jurisdictions with a history of race discrimination in voting would need to get pre-approval, pre-clearance from the Attorney General for significantly changing their election systems. In Shelby County versus Holder in 2013, the Supreme Court declared these provisions unconstitutional. This was a preventative mechanism, but it no longer exists since then. The other part of the Voting Rights Act was Section 2. It says that state and local governments cannot have election systems that discriminate against voters of color. In 1982, Congress amended this to say that proof of a racially discriminatory impact would be sufficient for liability. There didn't have to be proof of a discriminatory intent. This is important because it's so difficult to prove discriminatory intent. Rarely now will legislators openly express a racist motive. Louisiana versus Calais involves Section 2 of the Voting Rights Act, and it dramatically weakens that provision. There are 6 congressional districts in Louisiana. After the 2020 census, Louisiana engaged in redistricting. When the new districts were drawn, 1 of 6 had a black majority population. A challenge was brought saying that violates the Voting Rights Act. The population of Louisiana is 35% black individuals. Districting cases go to a 3-judge federal court panel, and the panel agreed with the challengers that this violated the Voting Rights Act, that it was a discriminatory effect against black voters for there only be 1 out of 6 districts that was majority black individuals in a state where the population was 35% black individuals. Louisiana then redrew its election districts, and they created 2 districts that were majority black individuals. This got challenged by white plaintiffs. They said it violates equal protection for the government to use race as a predominant factor in drawing election districts, and that's what Louisiana had done. The 3-judge federal court agreed with this. Louisiana then went to the Supreme Court and said, tell us what to do. When there was 1 district that was majority black individuals, we were found to violate the Voting Rights Act. When there were 2, we violated equal protection. The Supreme Court actually heard the case a term ago, in October term 2024, but didn't decide it. It put it over for re-argument in new briefing. On April 29th, the Supreme Court ruled 6-3 that Louisiana violated equal protection by creating 2 majority black districts. Justice Alito wrote the opinion for the court. Justice Kagan wrote a scathing dissent. Justice Alito reiterated that the government cannot use race as a predominant factor in drawing election districts. So the government cannot do this even when the justification is meeting Section 2 of the Voting Rights Act. He said there has to be proof of racially discriminatory intent. Proof of discriminatory impact is not sufficient. Justice Kagan, in dissent, pointed out that this effectively nullifies the 1982 amendments to the Voting Rights Act, and she said how difficult it's going to be, often impossible, to prove discriminatory intent. Justice Alito then went further, and he said, if the government can show a non-racial reason for districting, it then doesn't violate equal protection of the Voting Rights Act. And he said a non-racial reason would be drawing districts for a partisan advantage. So if a state legislature redraws districts to give more, say, seats to Republicans or to Democrats, that then is a non-racial explanation. Justice Kagan, in dissent, said, especially in southern states, there's a strong correlation between race and party. Black voters vote Democrat over 90% of the time. So it would be easy for any state legislature to discriminate on the basis of race just by saying it's doing so based on party. Indeed, immediately after the Supreme Court decision, Louisiana, Tennessee, Florida engaged in redistricting in a way that decreases the number of black representatives. And we will see this not just for Congress, but for state legislatures as well. There's another potential implication for this decision that transcends the area of voting rights. Justice Alito's opinion can be seen as calling into question disparate impact liability itself. There are many federal statutes and state laws that allow for liability on proving disparate impact. Title VII of the 1964 Civil Rights Act, that deals with employment discrimination, allows liability based on proof of discriminatory impact that doesn't have any proof of a discriminatory intent. In 2009, in Ritchie versus DeStefano, a Title VII case, Justice Scalia, in a concurring opinion, argued that disparate impact liability inherently violates equal protection. He said disparate impact liability requires that decision makers consider race in order to avoid liability. He said such consideration violates what he said is our colorblind Constitution. Many interpret Justice Alito's opinion in Louisiana v. Clay as echoing Justice Scalia's point. In fact, 3 weeks ago, the Office of Legal Counsel of the Department of Justice, in a memo to the Equal Employment Opportunity Commission, relying on Louisiana v. Clay, relying on Justice Scalia's opinion, said that it believed that disparate impact liability in employment cases is unconstitutional. If disparate impact becomes unconstitutional, it will be devastating for civil rights laws. To be clear, Louisiana v. Clay just did so with regard to voting rights in the 19 amendments to the Voting Rights Act, but the implications could affect so many civil rights statutes. The one path that seems open with regard to voting rights after Louisiana v. Clay is establishing a racially discriminatory intent. But that's what makes Louisiana v. Clay so important in terms of how the Supreme Court is going to apply the requirement for discriminatory intent. And here I want to talk about the next case in the handout, Allen v. Milligan. Allen v. Milligan involves the drawing of congressional districts in Alabama. There's a long history to this litigation. A 3-judge court found that Alabama had drawn the districts in a way that had a discriminatory impact and violated the Voting Rights Act. After the Supreme Court's decision in Louisiana v. Clay, it sent the case of Allen v. Milligan back to the 3-judge court in Alabama. It then issued a new opinion, a 78-page opinion, explaining that it found racially discriminatory intent in drawing the districts in Alabama. The Supreme Court quickly granted review, and on its emergency docket in a 6-3 decision, reversed the three-judge court. In a short opinion, among other things, the Supreme Court said the three-judge court had not shown sufficient deference to the Alabama legislature and the presumption that it was following the law. Justice Sotomayor, in her dissent, said, what else could the three-judge court have done? It held an elaborate hearing, many witnesses and documents, wrote a lengthy opinion finding intentional discrimination. This case seems to indicate that the Supreme Court is going to get much more difficult to prove and for courts to find intentional race discrimination. These, I think, are the most important cases of the term and have a profound effect on our democratic process and on voting. I want to talk about one other civil rights case here, and that's West Virginia versus PBJ. It's a very different context. It involves a West Virginia law that prohibits transgender girls and women from participating in sports that correspond to their gender identity. Federal District Court had found that this likely violates equal protection and Title IX of the Civil Rights Act and issued a preliminary injunction. Title IX says that educational institutions that receive federal funds cannot discriminate on the basis of sex. The Supreme Court reversed the lower courts. As to Title IX, it was 9-0 that there was no violation of that statute. All of the justices agreed that Title IX was explicit in allowing for separate sports teams for men, boys, as opposed to girls and women. But the court split 6-3 as to whether the West Virginia law should be regarded as sex discrimination. Here, Justice Kavanaugh wrote the opinion for the court. And Justice Kavanaugh, in the majority opinion, said this should be treated as sex discrimination under equal protection. In other words, they didn't treat it as a gender identity discrimination case. It's well established that sex discrimination under equal protection has to meet intermediate scrutiny. It has to be substantially related to an important government purpose. Justice Kavanaugh said that West Virginia has an important purpose in preserving competitive balance and fairness in girls and women's sports, in making sure that transgender girls and women don't take the place of cisgender girls and women. He said it's also about protecting safety of girls and women in girls and women's sports. And on this basis, the majority said no denial of equal protection. Justice Sotomayor wrote a blistering dissent. She said, this case involves PPJ, a transgender girl. She began taking male puberty-blocking hormones at age 10, and she's now taking female hormones. The question is, for somebody in this situation, is there a competitive advantage? Is there any safety threat to girls and women in these sports? So that's a factual question, and that should go back to the district court for fact-finding. The court, again, didn't talk about what level of scrutiny should be used for discrimination on the basis of gender identity. Because the court dealt with this as a sex discrimination case, there's reason to worry about whether the court was weakening intermediate scrutiny. Justice Kavanaugh, in his majority opinion, talked about the need for deference to the West Virginia legislature. Justice Sotomayor said such deference is characteristic of rational basis review, not intermediate scrutiny. Intermediate scrutiny usually required individualized proof, which wasn't present here. I think this continues a pattern of recent Supreme Court cases with the court ruling against claims of transgender rights. In March 2025, there's Trump versus Schilling, where the court upheld a Trump executive order excluding transgender individuals from the military. In June 2025, there's United States versus Scrimeti, where the court upheld a Tennessee law prohibiting gender-affirming care for transgender youth. In November 2025, there was Trump versus Orr, where the court upheld a State Department regulation requiring that somebody's passport list their sex as identified at birth. And I think West Virginia versus PPJ needs to be seen in that context. The second area that I list in the handout concerns the First Amendment and freedom of speech, and there's two cases here. The first of them is Childs versus Salazar. Colorado adopted a law that prohibited conversion therapy for gay, lesbian, and transgender youth. Colorado's legislature found that such therapy is ineffective and harmful. A woman who's a therapist who engages in talk therapy brought a challenge to this. She said it violated her speech to limit her ability to engage in talk therapy that was oriented towards trying to change someone's sexual orientation or gender identity. The lower courts upheld the Colorado law. The 10th Circuit in a 2-1 decision said that the government is regulating professional speech here. There needs to be more deference to the government in doing so. The Supreme Court, in an 8-1 decision, reversed the 10th Circuit. Justice Gorsuch wrote the opinion for the court. Justice Kagan wrote a concurring opinion joined by Justice Sotomayor. Only Justice Jackson dissented. Justice Gorsuch, in the majority opinion, said, this is a content-based restriction on speech. In fact, it's a viewpoint restriction on speech. If the therapist was trying to reinforce somebody's sexual orientation or gender identity, it wouldn't violate the law, but only if the therapist was engaged in speech to change it does it violate the law. Justice Gorsuch said, it's well established that such content-based restrictions on speech must meet strict scrutiny, that be necessary to achieve a compelling government purpose. The Supreme Court remanded the case back to the 10th Circuit for the application of strict scrutiny, but the majority left no doubt that it believed that the Colorado law was unconstitutional. Justice Jackson, in dissent, said that there are so many instances where the government regulates professional speech, so there needs to be deference to the government here. Doctors have to warn patients before they prescribe drugs or perform medical procedures. Lawyers have to give enough information to the clients to make informed choices. If a therapist knows that a patient is a threat to a third party, the therapist has to inform the third party. Justice Jackson said all of these instances are now vulnerable to constitutional challenge. She said there's no weight being given here to the Colorado legislature in its findings that such therapy is ineffective and harmful. I think that Justice Jackson is right in the sense that now when professionals face discipline or malpractice liability for their speech, they're going to be able to raise the First Amendment as defense, and the government will have to meet strict scrutiny. The other case with regard to the First Amendment is the National Republican Senatorial Committee versus Federal Election Commission. In 1976, in Berkeley versus Vallejo, the Supreme Court articulated the framework that's been used for campaign finance laws ever since. The court there said the government can regulate contributions to candidates or committee for candidates, but the government can't regulate expenditures. So imagine in 2024, someone had $1 million to spend for Donald Trump or Kamala Harris. The government could limit the amount that the donor could give to the candidate or committee for a candidate. Contribution limits are allowed, but the government couldn't stop the person from spending the whole $1 million by taking out ads directly. Expenditure limits are not allowed. You're familiar with the case Citizens United versus Federal Election Commission. It follows this framework and says the government can prohibit or limit contributions by corporations or unions, but the government can't limit expenditures that corporations and unions make with their election campaigns. One way in which this distinction between contributions and expenditures was enforced is by preventing political parties from coordinating their expenditures with candidates. The concern was that otherwise people could give a lot of money to a political party and it would just funnel it to the candidate. It would then circumvent any distinction between contributions and expenditures. In 2001, in Federal Election Commission versus Colorado Republican Party, the Supreme Court upheld the restrictions on the ability of political parties to coordinate expenditures with candidates. However, on June 30th, in the National Republican Party versus National Senatorial Campaign versus the Federal Election Commission, the Supreme Court, in a 6-3 decision, overruled the 25-year-old precedent, and the Supreme Court said that the law is unconstitutional in limiting coordinated expenditures between political parties and candidates. Justice Kavanaugh wrote the opinion for the court. He said, "This is regulating spending in elections. The government can regulate spending in elections without violating the First Amendment only to prevent corruption, and it has to be designed to prevent quid pro quo corruption." The Supreme Court said limiting coordinated expenditures between parties and candidates doesn't meet this, so it violates the First Amendment. Justice Kagan, in her dissent, lamented the Supreme Court again ignoring stare decisis in overruling a precedent. She also talked about how this very much will allow circumvention of contribution limits and further lead to the corrosive effects of money in politics. The bottom line now is, both at the national and state levels, political parties will be able to coordinate expenditures with candidates, and people who want to give a lot to a candidate could give it to the political party that will funnel it to the candidate. The third area that I list in the handout concerns the Fourth Amendment. And there's a very important case about the Fourth Amendment and privacy, Chatri versus United States. The issue in the case is whether police use of a geofence is a search within the meaning of the Fourth Amendment. To explain this, and the concept of a geofence, let me describe the facts of this case. There was a bank robbery in Virginia. The police had no suspects. So they went to court and got a warrant directed at Google. A feature of Google is location history. And if the location history feature is turned on a cell phone or a tablet, every 2 minutes it's recorded. And it's recorded with great precision. The warrant that the police got for Google was to give it a list of all the cellular devices within a radius, a geofence, within the time of an hour of the bank robbery. The warrant also then provided that after they provided that information, the police could go back to Google and get, for a smaller number of devices in a larger radius, a larger geofence, and for an additional hour. And then finally, the police could go back to Google for a small number of devices and get the names, phone numbers, email addresses. And that's exactly what happened here. Google initially provided a large number for within the geofence, then a smaller number for a longer period of time and a larger radius, and then was able to identify, police did, 3 individuals and want their names, phone numbers, email addresses, and one of these was Chatri. Chatri brought a motion to suppress. He said that this was a search within the meaning of the Fourth Amendment, that the warrant was inadequate, and that the evidence should be excluded. Chatri lost in the district court and in the United States Court of Appeals for the Fourth Circuit. Chatri, though, prevailed in the Supreme Court on the question of whether this was a search. Justice Kagan wrote the opinion for the court. It was 6-3. Justices Thomas, Alito, and Barrett were the dissenters, and each wrote a separate dissent. Justice Kagan began by saying that it's well established that there's a search within the meaning of the Fourth Amendment if there's an invasion of the reasonable expectation of privacy. She said here, the police are obtaining cellular location information that could reveal a lot about a person. It could disclose what doctor a person was visiting, where a person was worshiping, who a person was going to see. Thus, there has to be a warrant that's specific and has to be based on probable cause. Otherwise, there's the issue whether the evidence should be excluded. Justice Kagan's majority opinion relied heavily on a 2018 decision, Carpenter versus United States. Carpenter involved the police obtaining 127 days of cellular location information about Timothy Carpenter. It was designed to show that he was near banks or other stores at the time of robberies. And the Supreme Court, in an opinion by Chief Justice Roberts, said that that was a search within the meaning of the Fourth Amendment. There is a doctrine in the Fourth Amendment called the third-party doctrine that says we have no reasonable expectation of privacy to information we voluntarily share with third parties. The Supreme Court had previously said we have no reasonable expectation of privacy where there are bank records, with regard to the phone numbers we call and receive calls from, because we're voluntarily sharing them. In Carpenter, the Supreme Court rejected the application of the third-party doctrine in saying it was a search. Many questioned whether the Supreme Court might re-examine Carpenter. The 5 justices of the majority in Carpenter were Roberts, Ginsburg, Breyer, Sonora, and Kagan. Each of the 4 dissenters, Thomas, Kennedy, Alito, and Gorsuch, wrote emphatic dissenting opinions. There's been a change in the composition of the court. Many thought with Barrett replacing Ginsburg, the Supreme Court might rethink Carpenter. But it didn't happen. The Supreme Court applied and extended Carpenter. Carpenter was 127 days of information. Here the Supreme Court said even gathering information for a short period of time is a search. Police obtaining cellular information like this inherently is a search within the meaning of the Fourth Amendment. The court then said it would remand back to the Court of Appeals to decide whether the warrant was adequate and to decide whether or not the evidence had to be excluded. I think it's striking that 6 justices in the majority reaffirmed Carpenter, and even Justice Barrett in her dissent said she, quote, had no quarrel with Carpenter. There are so many ways that the police have of gathering information about people. So-called cellular tower dumps, where the police obtain a list of all the cellular devices connected to a tower at a particular moment in time. Use of drones by the police to gather information. Cameras on utility poles to monitor people's movements over a long period of time. I think Chatri provides a strong argument that all of these are searches within the meaning of the Fourth Amendment. I thus think it's one of the most important Supreme Court cases, and certainly the most important since Carpenter, about the Fourth Amendment as it applies to new technology. The fourth area that I list in the handout concerns presidential power. And as I mentioned, there were a large number of cases, both on the emergency docket and the merits docket, that involved challenges of President Trump's actions. I want to focus on the merits docket cases in 3 areas. The first of these is tariffs. And the case is Learning Resources versus Trump, decided on February 20th of this year. As you know, a core aspect of President Trump's economic policies is in the ability to impose tariffs. He has seemingly seen himself as having unlimited ability to impose tariffs at will and sometimes at whim. Indeed, just day before yesterday, President Trump imposed 50% tariffs on goods from Canada. Learning Resources versus Trump involves challenges to tariffs that President Trump imposed under the International Emergency Economic Powers Act. President Trump, in his speeches, the Solicitor General of the United States, in its brief, talked about the enormous importance of these tariffs for the United States economic and foreign policy. President Trump and the Solicitor General spoke in apocalyptic terms of what it would mean for the tariffs to be invalidated. Learning Resources Federal District Court had found the tariffs illegal. The court took the case before the D.C. Circuit could hear it, and then there's a companion case where the Federal Circuit found that tariffs were impermissible. The Supreme Court, in a 6-3 decision, ruled against President Trump and found the tariffs that were challenged in this case to be illegal. At the outset, it's important to note that all 9 justices agreed that the president lacked the inherent power to impose tariffs. One of the arguments that the Solicitor General made was that the president, by virtue of being president and in the conduct of foreign policy, could impose tariffs. No justice accepted that argument. Chief Justice Roberts, writing for the majority, said that tariffs are a tax, and Congress has the power to tax. Now, the actual result in the case was 6-3. Chief Justice Roberts wrote the opinion for the majority. There were concurring opinions by Justice Kagan, Gorsuch, and Barrett. There was a dissenting opinion by Justice Thomas, joined by Alito and Kavanaugh, and then Justice Kavanaugh wrote his own dissent. I think it was the lead dissent, joined by Justices Thomas and Alito. Once the court said that the president lacked inherent authority to impose tariffs, then the question is there statutory authority? As I mentioned, President Trump invoked the International Emergency Economic Powers Act. Chief Justice Roberts, writing for a 6-person majority, said this did not provide authority for President Trump's tariffs. Chief Justice Roberts said the statute authorized the president to, quote, regulate importation. Chief Justice Roberts said when Congress wanted to give the power to regulate or impose tariffs, it used the word tariffs. Chief Justice Roberts said no prior president had ever interpreted this statute to give the power to impose tariffs. In a part of the opinion joined only by Justices Gorsuch and Barrett, Chief Justice Roberts said, this violates the major questions doctrine. The major questions doctrine is the principle that the executive branch can act on a major question of economic and political significance only if there's clear guidance from Congress. Chief Justice Roberts said, there is no such clear direction from Congress here. Justice Kagan, in her concurring opinion, said, there's no such thing as the major questions doctrine. This is just a recent invention of the Supreme Court, and we don't need it here to strike down tariffs. Justice Gorsuch wrote the longest opinion, saying the major questions doctrine is based on the Constitution. He criticized Justice Kagan for not rejecting that, and Justice Barrett for seeing it as based on a statute. Justice Barrett wrote a separate opinion responding to Justice Gorsuch, saying that the major questions doctrine is based on statutory analysis. Justice Kavanaugh in his dissent said the major questions doctrine shouldn't apply in foreign policy at all. What's the bottom line of all of this? The president has no inherent power to impose tariffs. There must be a statute. The International Emergency Economic Powers Act does not authorize it. The day the case came down, President Trump criticized the Supreme Court in unprecedented vituperative terms, and he imposed new tariffs under different statutes. Those are now being challenged in the courts. And as I said just this week, President Trump imposed tariffs on Canada under yet another statute. Those are sure to be challenged as well. The second sub-area that I list here concerns the removal power, or more precisely, the ability of Congress to limit presidential removal. In 1935, in Humphrey's Executor versus the United States, the Supreme Court held that Congress could create federal agencies and Congress could provide that the heads of the agencies could be fired only for cause. That case involved the Federal Trade Commission and a commissioner on it. President Roosevelt fired the individual and claimed that he had inherent power to do so. The Supreme Court unanimously ruled against President Roosevelt and said Congress can create agencies, Congress can limit removal to situations where there's cause. That was the law for 90 years till when President Trump took office in January 2025, he proclaimed he would no longer follow Humphrey's executive. He said it's a unitary executive and he should be able to fire anyone in the executive branch of government. Rebecca Slaughter, by coincidence, was also a commissioner on the Federal Trade Commission. She had initially been appointed by President Trump in his first term, renominated by President Biden, and confirmed by the Senate. President Trump removed her without any claim that there was cause for doing so. She sued and she won in the lower courts based on Humphrey's executor. But on Monday, June 29th, the Supreme Court, in a 6-3 decision, overruled Humphrey's executor and ruled against Rebecca Slaughter. Chief Justice Roberts wrote the opinion for the court. He began by saying, it is a unitary executive. all executive power is vested in the president. So the president should be able to remove any officers of the United States. He said Humphrey's executive was inconsistent with that and therefore was overruled. Justice Sotomayor, in her dissent, again lamented not following stare decisis, the overruling of a 90-year-old precedent. She also said Congress, in carrying out its powers, should be able to limit removal. She also pointed out that when the Supreme Court first considered the unitary executive theory, in 1988, Morrison v. Olson, it was a 7-1 decision emphatically rejecting it. Chief Justice William Rehnquist wrote the opinion rejecting the unitary executive theory. Only Justice Scalia embraced it. This case is a substantial expansion of presidential power. There are so many federal agencies: the Securities and Exchange Commission, the National Labor Relations Board, the Federal Communication Commission, where there are statutes limiting presidential removal. In all of these instances, those statutory provisions are unconstitutional. Are there any limits that Congress can impose on presidential removal? What about civil service laws that limit the ability to fire individuals within the federal government? Well, the other case that I list here, Trump versus Cook, involves that issue. Lisa Cook is a governor on the Federal Reserve Board. The statute there, too, says there can be firing only for cause. President Trump claimed that Lisa Cook had engaged in mortgage fraud and removed her on that basis. To be clear, there was no finding by any agency or any court that Lisa Cook engaged in mortgage fraud. The Solicitor General argued to the Supreme Court that once the president finds cause, no court can review that. The Supreme Court, in a 5-4 decision, reversed. Again, Chief Justice Roberts wrote for the court and ruled in favor of Lisa Cook. The court talked in some detail about the history of the Federal Reserve, how it traces back to the first Bank of the United States during George Washington. The court talked about why it's important that the Federal Reserve has some insulation from politics in setting interest rates. Then the court said it was deciding narrowly. It was just ruling that Lisa Cook, under the statute, had a right to notice and be heard before she was fired. There's obviously a tension between Trump v. Slaughter and Trump v. Cook. Trump v. Slaughter says the president can fire any officials of the United States. Trump v. Cook says, but the Federal Reserve is different. Is it just going to be the Federal Reserve? Will there be other instances where Congress can limit removal power? We don't know at this point in time. And the final area that I want to talk about with regard to presidential power concerned birthright citizenship. Perhaps the most high-profile case of the term, Trump versus Barbara. When the United States began in 1787, it followed English law that everyone born in this country was a citizen of the United States. That was followed without exception until 1857, when the Supreme Court handed down its tragic decision in Dred Scott versus Sanford. There, the Supreme Court held that enslaved individuals were not United States citizens, even if born in the United States. About a decade later, the 14th Amendment was drafted and then ratified in 1868, and the first sentence of Section 1 was to overturn Dred Scott versus Sanford. It says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States in the state wherein they reside. In 1898, in United States versus Erwin Chemerinsky, the Supreme Court interpreted this provision. The Supreme Court said everyone born in the United States is a United States citizen. The Supreme Court said the phrase subject to the jurisdiction thereof just means that if there was an invading army and a foreign soldier had a baby, or there's a foreign diplomat who had a baby, those children would not be citizens. That was the law until January 20th, 2025, when President Trump issued an executive order. Under President Trump's executive order, only babies born to citizens and those with green cards, long-term lawful permanent residents, are citizens. A baby born to someone here on a visa, a baby born to someone who's undocumented would not be a citizen. Many legal challenges were brought. Every federal district court to rule, every federal court of appeals to rule, without exception, declared the Trump executive order unconstitutional. On Tuesday, June 30th, the Supreme Court affirmed. Chief Justice Roberts wrote for the court. It was 5-4 holding the Trump executive order unconstitutional. Justice Kavanaugh concurred in the judgment and said, though he thought the executive order was constitutional, he believed it violated a federal statute. So it was 6-3 to invalidate the Trump executive order, 5 of the justices on constitutional grounds. Chief Justice Roberts recited the history that I described, going back to the early days of American history, looking at Dred Scott, looking at the legislative history of the 14th Amendment, focusing on Wong Kim Ark. And the court unequivocally held that everyone born in the United States is a United States citizen. Justice Kavanaugh disagreed and would have found it constitutional, but found that a federal statute adopted in 1940 with the same language meant that the Trump executive order violated federal law. He said when Congress adopted this statute, Congress knew of how the Supreme Court had interpreted the language, said it had to be assumed that Congress was following that. Justices Thomas, Alito, and Gorsuch each wrote dissenting opinions, and they would have sided with the Trump administration on this. I think what's most important here to remember is that the Supreme Court said it is a matter of constitutional law that everyone born in the United States is an American citizen. After the decision, Speaker House Mike Johnson said Congress was going to consider a statute to change birthright citizenship. Trump versus Barbara means that such a statute would be unconstitutional. The fifth and final area I listed concerns the Second Amendment. From 1791 until 2008, not one federal, state, or local gun regulation was found unconstitutional as violating the Second Amendment. In the handful of Second Amendment cases, the Supreme Court always said the Second Amendment means what it says. It's a right to have guns for militia service. But in 2008, in District of Columbia v. Heller, the Supreme Court said that the Second Amendment creates a right of people to have handguns in their home for the sake of security. The court declared unconstitutional a D.C. ordinance that prohibited ownership and possession of handguns. And then in June 2022, the court decided New York State Rifle and Pistol Association versus Bruin. There, the court declared that there's a Second Amendment right to have guns in public. The court struck down a New York law that said that a person could have a gun in public only with a permit, and a permit would be issued only if there's cause for a person having a gun in public. Justice Thomas wrote the opinion for the court, and he said that the only gun regulations we allowed are those supported by history and tradition. The court said there's a two-step inquiry under the Second Amendment. First, is the government's action, its law, restricting the ability of people to have guns? And then second, is it supported by history and tradition? Is there, from 1791, a similar kind of law or close enough analogy? Well, this opened the door to hundreds, likely thousands of challenges to every imaginable type of gun regulation. When I taught constitutional law this spring, I said, there is no area of constitutional law that's generating more litigation than the Second Amendment. And I said, to use the technical term, this is a place where the law is a mess, as courts are disagreeing over history and tradition. I've always been very skeptical of this approach. Why assume that just because there wasn't a particular kind of gun regulation in 1791, that meant the framers intended to prohibit that type of regulation? Guns, firearms, our society more generally, are so different today than 1791. There were two cases this term with regard to the Second Amendment, and both struck down laws, both upheld Second Amendment rights. The less important is United States versus Hamani. It involved a federal statute, 18 United States Code, section 922G3, that says that somebody who is addicted to or uses illegal drugs cannot have a gun. It's a federal crime to do so under such circumstances. You might remember this was the law that was used to prosecute Hunter Biden. Ali Hamani was under investigation. The police questioned him. He was cooperative. He admitted he used marijuana about every other day. And the police discovered he had guns, and he was prosecuted under this law. The Supreme Court unanimously declared the law unconstitutional as applied to Hamani. The Supreme Court said there weren't analogs in 1791 to this kind of statute. The government pointed to habitual drunkard statutes, but the Supreme Court said those were very different than this. But the court was clear that it was a narrow decision. The court said it wasn't dealing with a situation if somebody was addicted to illegal drugs. The court said that it wasn't dealing with other parts of the statute that prohibit convicted felons from having guns. Just as applied to Hamani, this was unconstitutional. The other case is Wolford versus Lopez. Hawaii had a law that said that a person couldn't bring a gun onto private property open to the public unless there was consent from the owner of the property. So a person couldn't bring a gun into a restaurant, couldn't bring a gun into a shopping mall, unless the owner gave consent. The Supreme Court 6-3 declared the Hawaii law unconstitutional. California had a similar law, as did 3 other states. Justice Alito wrote the opinion for the court. Justice Jackson wrote the dissent. Justice Alito said that this limits the ability of people to have guns and bring them into stores and restaurants. He said an owner of private property could post a sign saying no guns allowed, but for the government to create such a presumption violates the Second Amendment. Again, the court looked to whether in 1791 there were similar laws. The court said there weren't historical analogs, and therefore this was unconstitutional. Justice Jackson, in dissent, said that this is about protecting property rights, protecting the ability of private property owners to exclude guns unless they want to post and say that it's permissible. Justice Jackson, in dissent, traced the history of Hawaii, saying go back long before statehood, and it had strict gun regulation. I think that these 2 cases, as I said, are indicative of a Supreme Court that's very aggressive in protecting gun rights. It's notable that on the last day of the term, the Supreme Court granted review for next term in a Second Amendment case, Vermanes versus Cook County, which involves whether the government can prohibit AR-15s, particularly dangerous weapons. I predict there will be many more Second Amendment cases for the court next year and the years to come. So that's my summary of what I regard as the most important cases. I think you can see that by any measure, it was another monumental year in the United States Supreme Court filled with decisions affecting the law, affecting all of our lives. And with that, I'll use remaining time if there's questions.
We do have a few questions. All right. So first, from Patrick Fabian. There were cases this term where the court did not defer to factual findings of the trial courts. Did the court articulate any standard for their decision not to accept trial court findings of fact?
It's a great question. It's absolutely right. And no, the court didn't articulate any standards. Let me take a case that I talked about, the second in the handout, Allen versus Milligan. The federal district court there found intentional race discrimination by the Alabama legislature. The Supreme Court reversed, saying that there hadn't been enough deference to the Alabama legislature and the presumption of good faith in districting. That just completely ignored the fact-finding. Or another case that I mentioned, though it's not in the handout, it's Trump versus Orr. It involved the State Department requiring that people put on their passports their sex assigned at birth, not their gender identity. The federal district court found, as a matter of fact, that this would cause people to be subjected to harassment and even violence in some foreign countries, and that it provided no benefit to the government. The Supreme Court gave no deference to that fact-finding at all, but nor did the court articulate a new standard. It's supposed to be on appeal that fact-finding from a trial court's overturned only if it's clearly erroneous. The Supreme Court clearly was not following that standard.
Okay, from Stuart Gardner. After Louisiana versus Clyde, What types of racial discrimination against Black people remain an unlawful denial of equal protection? If a white plaintiff asserts the remedy for that discrimination deprives them of some opportunity or benefit.
I want to focus on what Louisiana versus Calais is about, and that's voting rights. And what the Supreme Court says is proof of discriminatory impact will no longer be enough to show violation of Section 2 of the Voting Rights Act and allow the use of race in drawing election districts. In order to do so, there has to be proof of a racially discriminatory intent. Now, it's just about voting rights. But, as I mentioned, already the Trump Justice Department is saying that this means that all disparate impact liability should be regarded as unconstitutional, because all disparate impact liability requires that decision makers consider race in order to avoid liability. If the Supreme Court should go in that direction, as I said, it would be a devastating effect with regard to civil rights laws. So my direct answer to the question is that if the Supreme Court follows this, it's going to mean there has to be proof of intentional discrimination against Black individuals or people of color in order to violate the law as well as to violate the Constitution.
I think we can get a couple more in.
Sure.
From Michael Grady, do you think that the court's presidential immunity decision has encouraged President Trump's lawlessness, such as the firing of an IRS lawyer who told the White House that it was illegal for the president to try to influence who the IRS investigates or not?
In Trump versus United States on July 1st, 2024, the Supreme Court held that a president cannot be criminally prosecuted for official acts taken in office. In 1982, in Nixon versus Fitzgerald, the Supreme Court held that a president cannot be held civilly liable for official acts taken in office. I think this sends a message to President Trump and all future presidents that even if they violate the law, there are no criminal or civil consequences. I think it certainly then encourages lawless behavior.
From Wendy Strimling, in regard to the Slaughter case, if the boards/commissions have any quasi-adjudicatory function, why isn't the neutrality of the hearing body an issue? Did the arguments in the case address this fair hearing issue?
No, the Supreme Court simply said that the FTC is a part of the executive branch of government. It is a unitary executive, so Congress can't limit the firing of those who are at the head of the branch of government. But you're right, there are administrative law judges, or say immigration judges in that context. Can Congress provide any protection for removal for them? Or what about so-called non-Article 3 courts? Tax court judges serve a 15-year term. Magistrate judges serve an 8-year term. Bankruptcy judges serve a 14-year term. And they all have protection from removal except for cause during this time. Is that unconstitutional? Chief Justice Roberts, in his majority opinion, said the court was not addressing any of that in this opinion, and Justice Sotomayor, in dissent, raised that as an unresolved question. Now, I think there's a strong argument for distinction when it comes to the tax court or the bankruptcy court or the magistrate judges. I think you can argue that they're performing an adjudicatory task and not part of the executive branch of government. But you're right in your question. So can you say that for adjudicatory process within the Federal Trade Commission or administrative law judges within agencies? So I think this is an unresolved question.
12:59, let's do one more.
Sure.
What is the impact of Trump v. Slaughter on civil service laws? It doesn't seem like Cook resolved this.
Great question. Civil service laws have existed since the late 19th century, and they provide some protection from government employees for firing. President Trump is saying they're part of the executive branch. It's a unitary executive. I can fire anyone in the executive branch of government. That would even make civil service laws unconstitutional. However, the Supreme Court relies, in Chief Justice Roberts' majority opinion Trump v. Slaughter, on a case from the 1920s, United States versus Myers, that involved the president firing a postmaster general. And Chief Justice Taft's majority opinion draws a distinction between officers of the United States, inferior officers of the United States, and employees. I think one way to read Trump v. Slaughter is to say it's just about officers of the United States, and Congress cannot limit their removal. That it's a very different question if it's inferior officers or employees, and civil service workers are employees. But you're right, neither Trump v. Slaughter nor Trump v. Cook addressed the question of whether civil service protections, as limits on firing, violate the Constitution, whether or not they're inconsistent with the unitary executive. But I think the best argument is the distinction based on Myers between officers, inferior officers, and employees, and civil service workers being employees.
We're done for the day. If we did not, there are some questions in the chat that we did not get to. If you would still like to send those questions to the dean via email, he'd be happy to answer them. Hopefully a member of our wonderful alumni team can put his email in the chat, but I will spell it for you now. It is ECHER.
No.
Yep. It's EMERINSKY. Thank you, Erwin. At berkeley.edu.
Just E. Chemerinsky at berkeley.edu.
E. Chemerinsky at berkeley.edu.
Thank you so much for coming and continuing this tradition, and I look forward to doing it again next July.